Distinction between warranty and representation, finding intention. It is common for students to get a problem question in exam that requires them to distinguish between warranty and representation to ascertain the appropriate course of action or remedy. In order to make this distinction, case law shows that it is essential to look at the parties' intentions. Remember that distinction cannot be made by just looking at the words of a statement. It is necessary to look at the circumstances to find the intention. Now, let's try to find the intentions of the parties by looking at some case law. In Oscar Chess Limited versus Williams 1957, Mr. Williams sold a car to Oscar Chess Limited, who were the dealers. Mr. Williams had a registration book that stated that the car was a 1948 model. So he told Oscar Chess Limited that the car was 1948 model. But guess what? The car was in fact a 1939 model, and of course it was worth much less. The dealers were aggrieved and they claimed the difference in value between a 1948 model and a 1939 model as damages for breach of contract. It was held that the statement relating to the age of the car was not a term but a representation. The representee, Oscar Chess Limited, as a car dealer, had the greater knowledge and would be in a better position to know the age of the manufacturer than the defendant. Lord Denning explained very clearly the different ways in which the word warranty is used. In applying an objective test of intention, Lord Denning recognized that he must look not at the thoughts of the parties but at their words and behavior both. He thought that it was easier to infer a warranty when the person making the statement knew or should have known the facts. A reasonable person would infer that such a speaker would intend those words to be part of the contract. This is because a warranty, as a term of the contract, is a promise that the facts are true. If the facts are not true, then the promiser has breached the promise and breached his contract. So it is more reasonable to say that a statement of fact is a promise of the truthfulness of those facts, when the person making the statement is in a position to know the truth. In this case, Mr. Williams was not in a position where he should have known the true facts. He relied on the misleading registration book as much as the dealer, and so the statement was a representation and not a warranty. Would the result have changed if Mr. Williams was himself a professional car dealer? The next case might answer this question for you. In Bentley Productions Ltd versus Harold Smith Motors Ltd 1965, the dealer sold a car to Dick Bentley Productions Ltd, stating that it had done 20,000 miles as shown on the odometer. The odometer was incorrect, so the question arose, was the statement that the car had done 20,000 miles a warranty or a representation? The Court of Appeal held that the statement of how many miles were done was a term of the contract, because the Harold Smith Motors Limited were a car dealer and in a better position to know than the claimant about the truth of the statement. Now compare this decision with Oscar Chess Limited versus Williams, where Lord Denning thought that Mr. Williams was not in a position where he should have known the true facts. He relied on a misleading registration book. Note that in Oscar Chess, the roles were reversed and the sale was to a dealer by Mr. Williams. The sale was not by a dealer. This may explain why the non-expert dealer was not expected to know the age of the car. Also, in Oscar Chess versus Williams, Lord Denning thought if the statements were later on written down, it is likely that the parties intended that those statements to be the terms of the contract. If some statements are omitted when the contract was written down, those statements are likely to be intended as representations. This is not an absolute rule though. Omitted statements can still form warranties or terms if the appropriate objective intention is shown. However, this brings up the discussion of parole evidence rule, which we will discuss in the later lecture. There are some other ways of finding intentions though. Now look at this series of cases to see other ways of finding intentions. In Routledge versus McKay 1954, the claimant acquired a Douglas BSA motorcycle and sidecar by exchanging another motorcycle and paying £30. The registration document stated that it was a 1942 model, and this is what the defendant stated the year of the motorcycle to be when the claimant came to look at it. The motorcycle was in fact a 1936 model, but had been modified and re-registered by a previous owner. The purchaser went away thinking about it and then returned a few days later. A written agreement was produced to the effect of the exchange, which ended with the words, "It is understood that when £30 is paid over, that this transaction is closed." It was held that the statement was a representation and not a contractual term. The registration document was not prima facie evidence of a contractual term. Neither party was an expert, and there was a lapse of time between making of the statement and entering the contract, giving the claimant opportunity to check the statement. In Bannerman versus White, 1961, the claimant agreed by contract to purchase some hops to be used for making beer. He asked the seller if the hops had been treated with sulfur and told him if they had, he wouldn't buy them as he would not be able to use them for making beer if they had. The seller assured him that the hops had not been treated with sulfur. In fact, they had been treated with sulfur. It was held that the statement that the hops had not been treated with sulfur was a term of the contract, rather than a representation, as the claimant had communicated the importance of the term and relied on the statement. His action for breach of contract was successful. In Schawel versus Reade, 1913, the claimant purchased a horse from the defendant. The claimant went to see the horse and had told the defendant that he wished to use the horse for stud purposes. While he was examining the horse, the defendant told him that the horse was sound. He stated that if there was anything wrong with the horse, he would tell him, and told him that there was no need to get a vet to check him out. In reliance of these statements, the claimant purchased the horse, which turned out to have a hereditary eye disease, and was therefore not able to be used as a stud. It was held that the statement was a contractual term. The defendant had assured him he could rely on his words, and the claimant had communicated the purpose for which the horse was to be used. The defendant was thus in breach of contract. So, to summarize this topic of distinction between warranties and representation, we can say with confidence that representations are not terms of the contract, whereas the warranties are. In case where a statement is found to be a representation, there is no automatic right to damages. The primary remedy is rescission, but this may sometimes be barred. In the case of warranties, there is an automatic right to damages if the warranty is broken. And how do you distinguish a representation from a warranty? Look at the parties' intentions objectively as shown by the case law we just discussed.